Hello, and thank you so much for joining me at the Legal English Writing Masterclass. My name is Michael Davis, and I'm just going to tell you a little bit about myself. I have a law degree. I have it from the University of Aberystwyth, which is one of the best universities in the UK with a very prestigious law department. After taking my degree, I worked in the legal profession and teaching legal English for several years, and then I became a full-time legal English teacher. I've been teaching legal English for 15 years. I've worked with international lawyers from all over the world, from all continents, Africa, Europe, South America, you name it. I've worked there and worked with lawyers and law students from those continents. This is me, very happy, just by the Tower Bridge in London, and I think that's London Bridge directly behind me. I may be mistaken. And so obviously I'm based in London. I work with a lot of top law firms, Magic Circle law firms here in London and across the United Kingdom with my firm Legal English UK. And just before we start this course, I want you to consider some of the tools that you'll need to fully understand and fully comprehend and fully engage with this course. Do get a writing notebook if you can, or remember to jot down notes on your computer. I have two books available which will help you with the course: the Legal English Grammar Guide and the Legal English Workbook. Do look for them, or go to the Legal English UK website and go to the store where you'll be able to purchase those copies. Don't forget a pen, and obviously you should be using this course on a computer or a tablet computer or your phone, so you will be able to engage with the course in that way. And some rules and objectives from the class. For rules, I want you to be committed and stay focused. These lessons are short when you look at them. Sometimes the lessons are 5-10 minutes long. That should be enough time to fully comprehend and fully digest what I'm telling you. So just focus for 10 minutes, turn or move your phone away from you so you're not distracted by Twitter or Facebook, and just enjoy the lesson. So stay focused. If you have any questions, you can message me on this platform and I will answer very quickly. I answer all messages. And the objectives for this: we really want to develop your understanding of legal English and business English and give you the confidence to write fluently in legal English. This is a masterclass. It's around 2 hours long. Hopefully, by the end of this course, you will have a better understanding of punctuation, of how to write, and of grammar. That's the objective that I'm giving to you in this course. Enjoy the lessons, and I will see you soon. I'd like to start by looking at some different tips and different advice on how to improve your legal writing. And in this one, we're going to look at how exactly you construct sentences that your reader can understand and even enjoy, which admittedly is very difficult in legal English, but it's still quite possible, and I'll show you why. So you have to remember, as you're writing, that everything should be clear, concise, and engaging. The idea is to please the reader, whether that's a client, another lawyer, a law student, a judge. And the only way that you can do that is by making everything understandable. It's very difficult. Many native speaker lawyers struggle with this, and certainly a lot of non-native speaker lawyers struggle with this as well. Here's a quote from the late Ruth Bader Ginsburg about legal writing. and it's important that you remember this when you're working. My eye is on the reader. I try to be as clear and concise as I can be. If my opinion runs more than 20 pages, I'm disturbed that I can't do it shorter. She goes on to say, I can't bear legalese. If you can say it in plain English, you should. Clear, concise, engaging. So one way of doing this is through mixing your sentences up. And by that I mean that some sentences can be quite long, some sentences quite short. Now the average sentence should be about 20 to 25 words on average. On average. So that doesn't mean that every sentence should be 20 words. It means that if you look at the story, look at the article as a whole, then it should amount to about 20 words on average. So a mix of long sentences and short sentences, and I'll show you a very good example of something like this momentarily. Now take a look at this. This is a horrific example of a contract clause that's far too long. Let's read with me. The consultant agrees to indemnify and continue to keep indemnified the client against all actions, proceedings, claims, judgments, demands, charges, disbursements, or liabilities, including all legal expenses whatsoever or howsoever arising, together liabilities, which the client may suffer, sustain, or incur as a result of the consultant's provision, or otherwise, of the services, but not limited to liabilities arising from or connected with, i.e. accident causing bodily injury to the consultant. Now that's a very long contract clause, very difficult to understand. There are a lot of words that could be replaced in that contract clause, but instead the lawyer has decided to push everything they can into it so that they cover all eventualities. So it's certainly possible to cut that down, to cut that contract clause down, to edit it, to make it more understandable, because at the moment it's just too complicated. So you have to remember when you're working on legal writing, consider your word choice. Avoid archaic words, old-fashioned words, words that are unnecessary. Avoid doublets and triplets. These are words which all sound the same or have a similar meaning. Try and use the active voice as frequently as you possibly can. And of course, echoing the words of Ruth Bader Ginsburg, avoid legalese. Here's an example of some perfect legal writing from a 2015 case in the US called Advocacy against the Securities and Exchange Commission, the SEC. I'll read it through and you'll understand why it's such a good example of crisp legal writing. The Securities and Exchange Commission brought an administrative proceeding against George Jarksy Jr., charging him with securities fraud. That proceeding remains ongoing. In the meantime, Jarksy filed this action in federal district court seeking the administrative proceedings termination. He argues that the proceedings initiation and conduct infringe his constitutional rights in several ways. The district court dismissed his action for lack of subject matter jurisdiction. So you can see there you have certainly no sentence there is over 20-25 words. You can see at the beginning there's quite a long sentence, that's a bit of an introduction, and then a shorter sentence just to clarify what's going on, and then it carries on with a few more longer sentences and then a short sentence at the end. and it reads very well. It's a complicated case, but we can, if you read the full report, you'll understand the case quite clearly. Now, American judges seem to pay far more attention to legal writing and good legal writing than British judges. So it's likely in this course we'll be seeing more examples from American lawyers, American judges. But that doesn't mean that if you practice law in England and Wales or Scotland, Northern Ireland, you shouldn't take note of the crispness of this legal writing. Hello, and we continue now to look at legal English writing skills, about constructing sentences, and in particular we're going to look at how else you can make your sentences far more dynamic, shorter, crisper, more understandable for the reader. To do this, you can use more strong verbs in your work, and there are several ways to do this which we're going to look at in this particular lesson. Now, the first way is to avoid the use of to be, and the second way is for you to replace nouns with more dynamic verbs. So let's show you how you can replace nouns with more dynamic verbs. So here are two examples of sentences that are a little bit clunky and which could be easily cut down and edited and made easier to understand. Her thoughts on this amounted to getting him to contest the case. Okay, so it's a very complicated sentence. Personally, it's not a sentence I would write, but seeing so many work from students, and lawyers, this is what they tend to write quite frequently, because they think that it sounds like a very complicated, complex, dramatic, elegant sentence. In a second I'll show you how you can change it. Another example, her opinion was that it was not the way forward. Again, it's a sentence that you could read as written by a lawyer or a law student. So how can those two sentences be changed? But by the way, keep them in your mind. Let's have a look at the first one. So she argued that he should contest the case. So from her thoughts on this amounted to getting him to contest the case becomes she argued that he should contest the case. So the noun, all of this, her thoughts on this, becomes she argued. And it becomes, as you can see, dramatically better, easier to understand, less clunky, less slow to understand. The second sentence, her opinion was that. Again, the use of a noun, which can easily be changed to a verb. She felt that it was not the best way forward. You could also change it to she thought, she believed. There are different ways to do it. Now, as I said right at the start of this short lesson, there is no need to simply stop using this style of sentence throughout your work. You should vary your sentences, but at least be aware of what you're doing, and when you can and where you can, see if you can make them crisper and shorter. Let's look at the to be verb. The to be verb is, was, are, and were, for example. Okay, so again, the use of this structure can be seen as a little bit too much and too difficult to understand, too slow, too clunky. So what you need to do is make the sentences better, improve the sentences. Here are some examples. He is clear that this is going to happen. She is of the opinion that you should take the settlement. Okay, so you've got the to be verb there, he is, and then you've got the to be verb in the second example, she is. Okay, he is and she is, that's the use of to be. So, here's how you can change that. In the first one, he is clear that this is going to happen, becomes this is clearly going to happen. Now, there is some debate about whether or not you should use adverbs like clearly in this case. I've added it there because I wanted to keep the meaning from that first example. I wanted to not change the meaning in any way, but some would argue that you should delete clearly from that as well. Just say this is going to happen and that's enough. It's up to you. Let's remind ourselves of the second sentence. She is of the opinion that you should take the settlement. Quite a long sentence there, can easily be changed. She suggests that you take the settlement. Okay, so those are just a few examples of how you can start using more dynamic, stronger verbs in your sentences in order to get your point across. Do not be afraid to do this. Even though the sentences seem short, they do convey and communicate all the information that the reader needs, and you don't lose any formality in the language. Thanks for listening to this lesson. Hello, welcome back to the Legal English Writing Skills course, and this time we're going to take a little bit of a look at doublets and triplets, which are prevalent in legal English. You have to be aware of them. Sometimes you have to use them, sometimes you can try and avoid them. I just want in this lesson to make you aware of what they are and what they do, and how you can use them effectively in your writing. So effectively a doublet or a triplet would be 2 or 3 words that share a similar meaning, and this is because the English language is a hybrid of many different languages. So we have taken, appropriated, stolen, borrowed, call it what you will, many words from many other languages, largely Latin, German, French, and occasionally other languages like Turkish, Sanskrit, Spanish, whatever you want to name. There is probably a word in the English language that has been borrowed from another language. So if you take a look at this, you can see there that French, German, and Latin would be the predominant languages that are used in English. And here's an example of a word that you could use with a variety of synonyms in the English language. So meeting is obviously the generic word for when 2 or more people congregate in a room. You have a convention, which would be a larger number of people meeting in a room. You have a rendezvous, which is usually a one-to-one meeting, probably a romantic meeting of some sort. You have a powwow, which is more of a small group of people having a chat. And you have a session, which could be a direct synonym of meeting. Now, those words have come from Latin, from German, from French. Powwow has come from Native American, rather interestingly, and they're all used in a variety of different contexts in the English language, which is what makes the English language such a wonderful language to use, and I'm sure you'll agree with that. So because we've borrowed all these words, you have these doublets and triplets which are used in law and legal English, which are used to cover all eventualities. So if you take a look at this contract clause, which you may have seen before in one of the earlier lessons, you can see there are not only examples of doublets and triplets, but there are also quintuplets there. Let me read through it. The consultant agrees to indemnify and continue to keep indemnified the client against all actions, proceedings, claims, judgments, demands, charges, disbursements, or liabilities, including all legal expenses whatsoever or howsoever arising, together known as liabilities, which the client may suffer, sustain, or incur, so there's a triplet, as a result of the consultant's provision or otherwise of the services, including but not limited to liabilities arising from or connected with, i.e. accident causing bodily injury to the consultant. So you can see there it's a clause that tries to cover everything, and it uses a lot of vocabulary, and it can be confusing. Certainly in that third and fourth line, you could try and cut some of those words out. Charges, disbursements, you could use one word. Maybe you could say expenses, for example. Actions and proceedings, maybe you could just say proceedings, or you could say actions or legal actions. So there are ways to get around it. So you have to be aware that some lawyers will try and throw every word they can into a document just to cover everything, and maybe even just to show off. Let's have a look at some doublets now. So these are two of the more common doublets you might see. First one is fit and proper. You'll see it in corporate English and business English a lot. A fit and proper person is somebody who has the they have covered, or they have undertaken due diligence. Somebody has undertaken due diligence on them, so they know that this person is a fit and proper person. They know that they can run a business, or they can be on a board of directors. So for example, he failed the fit and proper person test and cannot join the board. So in some way, shape or form, that's a triplet by the way, he has maybe got a bankruptcy in his past, maybe he's been to prison, so he would not be a good fit for this company. And another example is terms and conditions, which you see a lot, of course. For example, make sure that you read the terms and conditions before you sign. There is no real reason why you can't just say terms there, or conditions, rather than both, because we know exactly what you're talking about. You're talking about the agreement, you're talking about the contract, you're talking about the small print. But this word has taken on a life of its own. This doublet has taken on a life of its own. Terms and conditions is now the word that we use, the expression that we use, and you can try and change it, but you will be in the minority, I'm afraid. So just be aware. There are so many doublets that we can't feature them all in this lesson, but here are a few. So in criminal law, you'll see the word aiding and abetting, which means to assist somebody in a crime. Somebody can be armed and dangerous. So in other words, they have a weapon of some sort. It could be a gun or a knife. You have assault and battery, also used in criminal law. Slight difference in meaning between the two, but most people don't understand what the difference is. So assault and battery would link to violence in some way. You have due and payable, meaning that it has to be paid. You have the heirs and successors, which is used in probate law to talk about who is going to inherit property. And you have part and parcel, which means partly. And you might see it in contract law or equity law, for example, land law, for example. And triplets are less common. I used one a minute or so ago, any way, shape or form, but that's more of a general English expression. Here are some more examples of triplets in legal English. So you have communicate, indicate and suggest, which effectively means to communicate. For example, he neither communicated, indicated or suggested that he wanted to purchase the house. And then you have cancel, annul and set aside, which of course means just to cancel. Example, she agreed to cancel, annul and set aside the agreement. As I said, triplets are less common, but you will see them occasionally. Those two are two of the more common triplets. We turn now to the passive and the active voice. I'll explain a little bit about what they do and what purpose they serve, and I'll show you which one to use in your writing in order for you to make good sentences. Now, if you look at these two examples, the victim was shot by the defendant and the defendant shot the victim. It's the same sentence but written in two different ways. In the first example, it's written in the passive voice, and in the second example, it's written in the active voice. Now, the goal that you have is to aim for most of your sentences to be of the second style, of the active voice. The traditional way these sentences are written: subject, verb, object. The defendant shot the victim. With passive voice, it takes a long time to get to the point of the sentence, and it can become a complicated sentence. But as with everything here, you can still use these sentences to make your legal drafts, your writing, flow well and fluently. So the passive voice, the action is performed on the subject, whereas with the active, the subject is the star of the show. And the actor is an afterthought in the passive voice. So you can see there, by the defendant becomes right at the end of the sentence. So you could even just say the victim was shot, full stop, and then we wouldn't even need to bother with by the defendant. With the active voice, it's the actor performing the action, and the active voice is shorter, it's more direct of a sentence, which is why when you read a lot of grammar books, that people will say, writers will say, that this is what you should be aiming for: short, direct sentences. Here's a quote from a lady called Henriette Ann Clauser, who wrote a book called Writing on Both Sides of the Brain, about the passive voice. The passive voice invariably comes across as pontificating, patronizing, talking down. It sounds insincere, even dishonest, and it makes the reader uncomfortable, not trusting, though usually the reader cannot put her finger on why. So bear that in mind. But of course, as I said at the start of this lesson, there are times when you can use the passive voice, and I'll show you a couple of examples momentarily. So let's remember, in the passive voice, the subject receives the verb's action. It receives the verb. In the active voice, the subject acts upon the verb. That's the difference. Here's another example of the passive voice. The deceased was stabbed in the back. The deceased was stabbed in the back. Okay, well, it's a perfectly fine sentence. But if you change it to active, it becomes the defendant stabbed the deceased in the back. Obviously, you could add by the defendant at the end of that sentence, but it takes a long time to get to the point. With the active voice, the point is right there. The subject is right at the start of the sentence, the star of the show. So when can you use the passive voice? Now, one way is when the actor is obvious to the reader, or the reader does not need to know who the actor is. So, for example, he was shot. Plain sentence in the passive voice. That's all we need to know. He was shot. Or he was shot by Jim. Again, that's passive, but we had an idea, or we don't really need to know that it was Jim who did the shooting. Another example, the barrister cross-examined the defendant and the judge warned counsel. Two examples of active voice that tell you exactly what is happening or what happened in this situation. Short, crisp sentences, which is what you should be aiming for. Hello, and we are talking about the subject, verb, and object now. And the crucial slogan that you have to keep in your mind as you write is keep them together. Keep the subject, verb, and object as close together in the sentence as possible. So that's our agenda for this lesson. Focus on getting you to keep the subject, verb, and object as close together as possible. Have that at the beginning of the sentence so you don't confuse the reader, and avoid separating the words as much as possible, which is, of course, a synonym of keep them together. Why is there no number 4? Because all we would say is keep them together. So this is Thomas and Chloe, two beautiful couple. This is a simple sentence with subject, verb, and object. Thomas will marry Chloe later this year. Absolutely perfect sentence, tells you everything you need to know. But what could happen if somebody has a tendency to write too many words in a sentence? It becomes complicated. If all goes well, Thomas, who hails from Toronto in Canada, will, in all likelihood, get married to a lady from the United States known as Chloe. Some great information there, but it's becoming a confusing, cloggy, long sentence with too many clauses, too many complications, and you don't need all that information necessarily. So here's a legal sentence now. The proposed statute gives to any person who suffers financial injury by reason of discrimination based on race, religion, sex, or physical handicap the right to seek legal redress in a civil court. Very complicated sentence, something that you will see frequently in legal English. There are ways to clear that up. If you have time, just pause the video now, see what you can do with that sentence, see how you would change that sentence, make it more direct, put the subject, the verb, and the object at the beginning of that sentence to make it better for the reader. And when you're ready, we'll take a look at a proposed change. The proposed statute offers legal redress to any person who suffers financial injury by reason of discrimination based on race, religion, sex, or physical handicap. So that's another way. You can also play around with that sentence in other ways too, but it's a good way of putting the subject, verb, and object right at the beginning of the sentence and telling you right at the start what's so good about the proposed statute. Here's another one. A claim which, in the case of negligent misconduct, shall not exceed £500, and in the case of intentional misconduct shall not exceed £1,000, may be filed with the county court by an injured party. So again, very complicated, complex sentence, lots of words there. I think it takes about 20 words to get from the verb to the object. So clearly that needs to be changed. If you want to, you can pause the video and you can consider this sentence for a few moments, play around with it, see if you can change it. And when you're ready, let's take a look at another version of that sentence. So any injured party may file a claim with a county court. So there's your introductory sentence, and then we've split this up. So you have a second sentence. A claim must not exceed £500 for negligent misconduct or £1,000 for intentional misconduct. And just by the way, there is a comma there after misconduct. This has been adapted from American English. In the UK, no need for a comma by there, okay? So it's it depends. But both types of English, both acceptable. Your choice. But as we always say, if you use American English, stick to American English. If you use British English, stick to British English all the way through your document. So that concludes our look at the subject, verb, and object. And as our friend is saying here, keep them together. Subject, verb, object, stay together right at the beginning of the sentence. Do not confuse your reader. The Legal English Writing Skills course continues now with a look at working words and glue words. And so the first question, of course, is what are they? Well, working words carry the meaning of a sentence. Okay, so working words carry meaning and sentence would be the working words of that sentence, and of a would be the glue words. So glue words essentially are these filler words, articles, prepositions, etc., that are not essential to a sentence, while working words are needed within that sentence. And the idea behind this lesson is that as you write and as you develop your writing skills and improve your writing skills, you focus on writing fewer glue words and more working words and fitting them into your sentences to make your sentences more dynamic and better for the reader. So here's a list of examples of glue words. So you have prepositions like in, of, to, by. We also have there, from, was, for, some, and much. Okay, so they're all examples of glue words. There are, of course, many, many more, which we can't go into now. So remember, the idea is that you have fewer of these in your sentences. So if you take a look at any sentences that you've written recently, and if 50% of that sentence is made up of glue words, then you need to be working and developing and improving your sentences and adding more working words. So for example, let's take a look at this sentence here. A 5-minute recess was requested by the counsel for the defense. So there are quite a few glue words in there, like a, was, by, the, and for, and the. So you need to look at that sentence, think about it, and try and work out a way of cutting it down and restricting those glue words. Here's one way you can do it, by changing to this sentence here. Defense counsel requested a 5-minute recess. So all of a sudden we've gone from having, 5, 6 glue words down to 1 glue word. And the sentence is made up completely, almost completely, of working words, which makes a big difference. Another example, in certain circumstances, a jury trial may not be the best idea, as jurors can be even more unpredictable than judges. Now again, if you saw that written down, you could understand it quite easily, but of course it can be changed, it can be made shorter, and here's one way of doing that. Sometimes, so instead of in certain circumstances, we've cut 3 words down to 1. Sometimes jury trials are not the best idea, as jurors can be less predictable than judges. Okay, so the idea is that anytime you see an expression that has too many words, you can cut it down to 1 word or 2 words, then please do so. And anytime where you see glue words, try and restrict them. Another example. By really going over your case files and ensuring that everything is up to date, you should be able to save time. So of course, words like by, really, and, that, is, to, these are the words that you need to be thinking about and considering and asking yourself, do I really need them in my sentences? For example, really, at the top there, is that absolutely necessary? Is that really necessary to the sentence? You really have to ask yourself this question. This is how it can change. You should be able to save time by updating your case files. So suddenly there's a dramatic shift in that sentence. A very long sentence has become far more dynamic, and you've put yourself, or you've put the reader, right at the heart, right at the start of that sentence. You should be able to. So that concludes this look at glue words and working words. If you have any questions about this, don't forget to message me and I'll be happy to answer. Thank you. Hello, we are going to look at punctuation right now. We'll take a few lessons to look at this because it's quite a complex subject that a lot of students struggle with. So it's worth spending a little bit of time on it. We're going to look at two particular punctuation marks today, but let's quickly review all the available punctuation marks to us as writers. So we have the full stop, the question mark, the exclamation mark, the comma, the semicolon, the colon, the dash, hyphen, parentheses, brackets, braces, the apostrophe, quotation marks, and ellipsis. Most of them will come in handy for us at some point or another, so it's worth looking at all of them. Possibly the exclamation mark is something that you should resist using frequently, but you could use it in reported speech, so we will take a look at it. We're going to take a look at three right now. So that's commas, semicolons, and colons. Now, commas typically separate ideas within a sentence. That's one of their jobs. They have a couple of jobs. And semicolons connect independent clauses. We'll see how momentarily, and colons are used to introduce examples or explanations. We'll look at that in the next lesson in part 2 of punctuation. So let's first talk about the comma, and you can see here we can use a comma right at the start of a sentence just after a discourse marker, a linking word, in order to highlight what is about to happen in the sentence. So if you think about all of these sentences, if you were to speak them, if you were to say them, you would take a pause after the first word or the first two words. So for example, however, we wanted to, in addition, they needed to, first of all, we would like to. So it is acting as it is supposed to be there. It's a pause after the introductory word or words before you getting to the main part of the sentence. Another way to use the comma is when you have additional information that is not really essential to the sentence but has just been added on. So, for example, the house, which was worth £100,000, was located in Barcelona. The man, who was 32, lived with his wife and daughters. So those two clauses right in the middle of those sentences, they're not particularly needed, but they're useful for the reader to know, arguably. And therefore you need a comma just to separate out the important information from the not so important information. If you want to look up more about this, these are called non-defining relative clauses. Worth looking at, not a complex piece of grammar, even though textbooks seem to think it is. Take a look and try and understand it a bit more. Another way to use the comma is with a dependent clause being used before an independent clause. So a dependent clause is a series of words which cannot stand alone as a sentence. An independent clause is a series of words which could exist as a sentence by itself. Instead, they have come together into one sentence. So you can have sentences of different clauses, of different independent clauses, dependent clauses. In this sentence, you can see here, you have a dependent clause after the trial. So clearly that could not be a sentence on its own. So it's a dependent clause. It depends on the next clause to make the sentence. After the trial, comma, the defendant thanked his lawyer profusely. So dependent clause, independent clause, put them together, you have a sentence that makes a lot of sense. Profusely, by the way, means enthusiastically, confidently, with energy. Next one, we have the use of a comma where you have two long independent clauses, but there must be a conjunction there somewhere. For example, so or but. Okay, so for example, here you have two independent clauses, so this could be two sentences by itself. The judge was determined to ensure that the case be heard today, comma, so he gave the defense time to locate the witness. Now, easily that could be two sentences, but we've dragged them together, put them together, added a comma and a conjunction, a coordinating conjunction in so, and therefore you have a new sentence, a bigger sentence, slightly more complex sentence, something to impress the reader by. Let's have a look now at the semicolon. Now you can use the semicolon with two independent clauses. The semicolon is more powerful than a comma, so you don't need a coordinating conjunction to put these two independent clauses together. So, just one example for now. The defendant was found guilty, semicolon, he faced sentence next week. The defendant was found guilty, he faced sentence next week. So that's where a semicolon is used. And if you have any questions, don't forget to message me. I'll be happy to answer. See you in the next lesson. Hello, we continue now with the Legal English Writing Masterclass, and we're going to look at punctuation. This is a series of lessons on punctuation because it's an important subject. Not many teachers deep dive into punctuation, unfortunately, so we really need to try and explore this and get you to understand all these different punctuation marks and the purposes they serve within your writing. What we're going to do, first of all, is just take a look again at that list of punctuation marks that we saw in the previous lesson. And remember, there were 14 punctuation marks. We looked repeatedly at the comma and the semicolon. We also briefly looked at the colon. We're going to look at that in a little bit more detail right now. We're also going to take a look at a few other punctuation marks. Now, colons, the dashes and hyphens will be featured in this lesson. So colons are used when we introduce examples or explanations into our writing. I'll show you an example of that momentarily. We have two types of dash, which we'll talk about soon, and how they are used and why they are used and what size they are. And we also have hyphens, which are used with compound words, compound nouns, compound adjectives. So we'll look at that in a second. First, let's go back to colons. And you can see here it's to introduce a list, for example. So here we have, there were three people there, colon, Stephen, John, and Susan. And then they can also be used to highlight something that you want to end the sentence with. So you can see here, the jury delivered its verdict, colon, guilty. Okay, so because of the colon, the word guilty there has a big effect. It has a big impact on the reader. If that sentence read, the jury delivered a guilty verdict, it wouldn't have the same impact, I would argue. So there you go. That's how you can use the colon. So there are two types of dash, the N dash and the M dash. The N dash should be slightly shorter than the M dash. Okay, the N dash should be about the size of the letter N, and the M dash should be about the size of the letter M for Michael. Okay, now I've looked on my keyboard and I can't see a difference on the keyboard, so it's going to be very difficult for you to replicate that while you're typing. But if you are handwriting, and I think some people still do, then bear that in mind, okay? N dash slightly smaller than the M dash. So let's look at how you can use both of them. Now the N dash is used when you're talking about a range. So for example, the World War II was between 1939 to 1945. You use the N dash for that. He's taking a plane from London to New York City. You use the N dash for that. The M dash replaces a comma or a colon, as we've mentioned before, and it emphasizes the end of a sentence. So, for example, the jury gave their verdict guilty. We saw in the earlier example with the colon, you could put a colon there. The jury gave their verdict, colon, guilty. Okay? Your choice, whether to use the M dash or the colon. And we also have hyphens. Now these join two or more words together in order to create a compound. Okay, but bear in mind that not every compound requires a hyphen. Some compounds are just two words separately with no hyphen. Sometimes you join the two words together to create a new word. There is no particular rule about this, so what you're going to have to do is check in the dictionary until you're comfortable enough and confident enough to use these words effectively. But here are a few examples of compounds. You have a 5-year-old boy, that's typically hyphenated. You have a 20-year-old building, that will be hyphenated, okay? 20-year-old will be hyphenated. You have a well-read law student, that's hyphenated too. Okay, so that's how you can use the hyphen. You use them in compounds. And so as I mentioned before, the M dash is typically longer than anything else, but in reality, unless you're on a specific website, I know Medium, for example, will put the proper M dash in there when you type it, which is fabulous. But I think most of the time, if you're writing an email, if you're writing a document in Word, they won't differentiate between them. So you could maybe put 2 dashes there and see what happens, okay? So that's been punctuation part 2. Thanks for listening. I'll see you at the next lesson where we'll talk about a few more punctuation marks. We're getting into some of the rarer punctuation marks in the next few lessons, so I look forward to seeing you for that. Hello, and we continue our exciting journey into the world of punctuation marks with part 3 in our series of lessons on this magnificent subject. So far we've looked at the comma, the semicolon, the colon, the dash and the hyphen, and we're going to look at 3 more punctuation marks right now, and of course we'll have another lesson or 2 on the other subjects, and you can of course listen to those later. So today we're going to look at parentheses, brackets and braces. Bear in mind that the main one that we're looking at today will be parentheses. Brackets and braces can be used, but they are rarely used. And if you do see them, you're probably looking at an example of some engineering or some maths work rather than the law. But of course, we're looking at all punctuation marks. It's good to get a comprehensive understanding of this. And so few people know about all these different punctuation marks, and what we're trying to do is make you the best English speaker, English communicator, legal writer that you can possibly be. So knowing all these punctuation marks is absolutely necessary. So let's first of all look at brackets. So these are the square brackets that you may have seen on a keyboard. They tend to be on the right hand side of the keyboard next to the return button. So as you can see, they are used primarily in academic writing. You're not going to see them anywhere else usually. And if you do see them anywhere else, it's probably because they are adding additional information to a quote, where they fix errors, they add information, or they add emphasis in that quote. and you can also use them with seek, S-I-C. So seek is the Latin word that acknowledges that somebody has made an error. Okay, so let's take a look at some examples. So the lawyer wrote that the defendant had, and then quote, not been, and the lawyer obviously spelt the word been incorrectly for some reason, so you have there in brackets seek. Okay, some people say sick, I say seek. I think it sounds better, but up to you. So not been anywhere near the location of the incident. It's in square brackets, so we know that the person who is writing this quote is aware that the lawyer has made a mistake, but has kept it in for whatever reason. Another example, another quote, the Court of Appeal, square brackets, in London was about to hear an enthralling case. So again, you have the square brackets there just to emphasize, just to add a little bit of more information for the reader about where the Court of Appeal is. Now parentheses, these are the most common and you're no doubt familiar to these. Now these will add extra information for the reader into some writing, and essentially it does the same job as a comma does in some circumstances when it adds bits of information. Don't forget to go back to the lesson on the comma. I think it was last lesson or the lesson before, just to remind yourself of it. So here's an example. The case, brackets, or you could say a comma, of course. The case which was due to be heard in February has been pushed back to the 5th of May. Okay, so we got parentheses there. The case, open parentheses, which was due to be heard in February, close parentheses, has been pushed back to the 5th of May. It's a bit of extra information, and of course, if you put commas there instead, it would not change the meaning. And then we have braces. These are also usually on the right-hand side of the keyboard, right next to the return key, close to the brackets. They are used in technical language usually. So if you are writing a contract that contains lots of mathematical equations, which is of course possible, or if you deal with programming language possibly, then you're going to see these braces. You're not going to see them anywhere else. So there you have an example there of a mathematical equation containing braces. So that's punctuation part 3. Don't forget to stay tuned for the next part, part 4, where we're going to look at a few more punctuation marks. Thanks again for watching and for listening. Speak soon. Hello. So earlier in this course, I promised that the next punctuation marks that we're going to look at would come at the end of this series of lessons, but instead, because of a little bit of a snafu, a little bit of a mistake, this is now part 4. Okay, so part 5 will look at some other punctuation marks, but this one is going to look at the top 3 there, the full stop, the question mark, and the exclamation mark or exclamation point, call it what you will. Apologies for a little bit of confusion. Hopefully it doesn't impact your understanding of punctuation marks. These are important, but arguably they are the easiest ones to do, so we can get through them very quickly. So we have the full stop, the question mark, and the exclamation mark. Now the full stop we can use with declarative sentences, so those sentences that declare something, that state something, and you can also use them after abbreviations, at least some people do that. Question marks are used with direct questions, and exclamation marks are used to add emphasis. So there's the full stop. It's called the period in the US, by the way. And there you've got a simple statement there. The case ended yesterday, subject and verb. The case ended yesterday. And then you have Martin Stevens, Esquire. Esquire is the word used in the US for an attorney, for a lawyer. So in the US, you will see that quite frequently with the ESQ, full stop or period. In the UK, we don't tend to use that. Esquire is a bit of an old-fashioned word. It used to be another word for Mr., but you don't see it too often now. You'll see it more often in the US, so then you can use ESQ full stop. Question marks, so there are a couple of questions there as examples. Did you see the suspect? Who is Jenny's lawyer? And you see the cadence rises at the end of the question as well. Just one thing that we can slightly note, in some countries they have a little question mark at the start of the question just to indicate what's going to happen. We don't do that in the English language. It might be a very good idea to do it though. And then you have exclamation marks. Try and avoid these in legal writing if you can, unless you are quoting somebody. And maximum of 1 exclamation mark if you possibly can. Sometimes people put 3, 4 exclamation marks, and it loses its emphasis, in my opinion. So there are a couple of examples there. This is infuriating! Exclamation mark. I can't believe this! Exclamation mark. Use them in quotes. Try not to use them in your legal writing if you possibly can. I think the former copy editor of the New York Times once said that a maximum of 1 exclamation mark in an entire article is 1 too many. So that concludes punctuation part 4. So next will be part 5, and you'll find out about a few more punctuation marks. Thanks again for watching and listening to this. Speak soon. Hello and welcome to part 5 of our series of lessons on punctuation marks. And so far we've looked at the comma, semicolon, the colon, dash, hyphen, parentheses, brackets and braces. In the next lesson we'll take a quick look at the full stop, the question mark and the exclamation mark. I've left them until the end because they're arguably the easiest. And this time we're going to look at the 3 at the bottom. That's apostrophes, quotation marks, and ellipsis. Now, apostrophes we can use when we have missing letters. We can use it with possessives. And there's one other reason. You'll have to keep watching to find out. Quotation marks we use when we have direct speech. And in writing now, more people are using direct speech than indirect speech. So quotation marks are becoming more prevalent, more common. And we also have ellipsis, which is 3 dots. And we use 3 dots, we use ellipsis when we have missing words, deliberate missing words usually. So apostrophes there, you can see what an apostrophe looks like. We use it when we omit letters from a word. So letters are not included in a word to save space or to make things more informal. We can use it with possessives, with possessions, when talking about what belongs to somebody. And we can also use them when we have plurals with lower case letters. So we're going to have 3 examples now of these 3 just to help you along, starting with omission of letters from a word. And you can see there, she didn't talk to the man. So if that was written out in full, it would say she did not talk to the man. But to save space, you put the apostrophe there, she didn't talk to the man. When we talk about possessions, it's Jenny's brief, for example. So it's the brief that belongs to Jenny. And when we have plurals, as I said before, you use an apostrophe with lowercase letters. So we split the cases into 2 groups, A's and B's. So there's a selection of A's and a selection of B's, and therefore you use an apostrophe. And there you can see a couple of examples with quotation marks. In the first one, the court will come to order, announced the judge. Then you can see in the second example, we use single quotation marks, 1 quotation mark rather than 2, when you have a quote within a quote. So for example, Mike told the court that he would not do it even though Tom had said, and then you have that quote within a quote, you ought to, when they spoke yesterday. An ellipsis, so it's three dots, and it denotes missing words or letters, and you should be using it when there are unnecessary words in a quote that you don't want to include in that quote because they're not important. Somebody has said them, they exist, but we don't need to know about it. Example. She began to list the cases that she had presided over. Allen against Johnson. Tom's against Unique, ... So obviously she continued. There were so many that some people were begging her to stop. That's punctuation part 5. Any questions? You know where to leave them. Thank you so much. See you in part 6. Hello and welcome back to the Legal English Writing Skills course. My name is Mike Davis and we are going to look now at writing a letter. So some people still continue to do it despite the popularity of email, and hopefully your law firm does this now and again, and this lesson will come in handy for you. So we're going to look at the format of said letter. Here's an example of a famous letter from 2018 written about a political issue in the UK, and you can see that you have the address of the recipient on the left hand side, and then on the right hand side you'll have the other details such as the date, references, and anything else. Some law firms do it in this way. Mishcon de Rea, very famous law firm in the UK. Some other law firms would put everything onto the left hand side. Of course, check the style of your law firm to understand that. So here's the structure. The letterhead at the top, obviously, and then you would have the address of the recipient underneath. References, your ref and our ref. We'll look at that in a second. You'll have the date, the salutation, that's Dear Sir, Dear Terry, Dear Mr. Jones. Then you'll have the subject of the letter, usually about 5 or 6 words. You'll have the body of the letter then, 3-4 paragraphs, the signature, and then the name. So starting with references, it'll be typically the case where you have your own reference and you'll have the reference of the other firm. The reference is typically the initials of the lawyer or whoever is writing the letter, followed by the initials of the secretary or the typist, followed by the file number, maybe the name of the client. In terms of the date in the UK, we start with the day, then the month, and then the year. In the US, it starts month, day, and year. So September 11 in the US would be 11 September in the UK. On to salutations. So these occur right at the start of the letter. And you can see there, if you know the name of the person, it's Dear Mr. Jones and then yours sincerely at the end. If you don't know the name of the person or you're writing to the corporation or the business, then it's Dear Sirs and yours faithfully. Dear Sir or Madam obviously is more politically correct now. And again, you would end the letter with yours faithfully. If you know whether the lady that you are writing to is married, then you would write Mrs. If you know that she is single, it's Miss. If you're not sure, then it's Ms. MS. Mr. applies to all men, whether they're married or single. Master is for a child. Esquire is used when you're writing to lawyers in the US, but you'll put it in the address. And sometimes when you're writing to law firms in the US, you can start simply with gentlemen and then go straight into the letter. They do things very strangely in the US. On to the subject line now. So very similar to an email subject line. No need to write RE or in reference to or reference anymore. That's a bit old-fashioned. Just go into the subject heading, underline it, put it in bold. Here are a few examples. Sale of 23 Hedge Row, your contract with Minotaur, employment tribunal case 3421048. Just basically a line, 5 words or fewer. Tell the person exactly what to expect in that letter. We continue with letter writing now, and this time we are going to concentrate on the body of the letter, the main paragraphs in a letter. And I turn back and draw your attention to the letter that we looked at in the previous lesson. So this was about an important political matter here in the UK back in 2018. And the reason why this letter has been chosen is because it shows some very good language use, good use of adjectives, good functions of paragraphs, and I like the language being used there. I'm not going to go into too much detail about the letter now, but if you can see, for example, in the second paragraph, which starts while your decision is welcomed, the basis on which you seek to explain your belated volte-face is entirely disingenuous. What a beautiful sentence that is. Entirely, arguably we don't need that word because we're trying to avoid adverbs. But still, the sentence tells you everything you need to know. It's direct. It's still formal. I think it's a really beautiful sentence. And you can see there right at the end of that same paragraph, you have entirely misrepresented. So again, whoever wrote this letter is a fan of the adverb entirely, clearly. Nothing wrong with that. Maybe you could change that. But still, it's quite a well-written letter, and this is what you should be aiming for when you write your letters, of course. So here are some of the ideas that you should have in the back of your mind when you're writing your letters. You should vary your sentences. So remember, we've talked before about your sentences being an average of about 20 to 25 words. And clearly that does not mean that every sentence has to be 20 to 25 words. It means that when you look at the sentences as a whole, they vary. So some sentences will be 7 words, 8 words, some of them will be maybe 30 words, but they average out at 20 to 25 words. You should also be aiming for short paragraphs. Too often I see very long paragraphs in letters, and when I see those very long paragraphs, I am turned off from reading the letter. I might have to read it, but it fills me with dread that I have to read it. So aim for short paragraphs, okay? If you have an idea, keep it into one paragraph, and then in the next paragraph you have a new idea. Don't forget to punctuate correctly, of course. We have a few lessons in this course on punctuation. Look at them again, and understand how punctuation works and how to use it correctly in your writing. Keep your grammar consistent. That's also a problem that we see in lawyers and law students. The grammar is sometimes all over the place. So keep an eye on that. When we talk about register, we're talking about whether writing is formal or informal, and you're writing obviously for the reader. So if you're writing to a client, you'll have a different style of language as compared to writing to a corporation or to a law firm. So keep that in mind. Don't forget to use appropriate vocabulary. We saw there some very good use of adjectives. So, there are millions of words available to you in the English language. So think about that. And if you can find an appropriate adjective and you can avoid an adverb, then do so. And don't forget discourse markers or linking words. Words like however, in actual fact. These are great for the starts of paragraphs and the starts of sentences to help your reader understand what is about to happen. So Here's a few examples now. Here are a few examples of register. And in the first one, I am writing about your house in Cornwall. Very basic sentence. Probably a lawyer would write something like, I write regarding your property in Cornwall. So remember, we are focused on plain English, but not too plain. We still have to keep some semblance of formality when we write. He says you stole his watch. If you wrote that in a letter, arguably it's too direct. We need to coat it. We need to soften it slightly. My client alleges that you took his watch. Do not take any more photocopies. Again, too direct. You are urged not to take any more copies. So I want to look now at writing a good letter, writing a great letter, making the letter stand out from all the other documents that people get every day, all the other emails that we get every day. And looking at the kinds of questions you should be asking yourself as you write this letter. So first of all, if you look on the left-hand side of the screen, these are some of the problems that people have complained about with legal letters specifically. So people say, readers say, that these letters are too complicated. They have too much legal language. So frequently solicitors and barristers, lawyers are using too many legal terms, too many legal phrases. The letters are far too lengthy. So in some cases going to 2, 3, 4 pages. Paragraphs are far too long and too complicated. In terms of the formatting, the font sizes are too small, so very difficult for the reader to understand what's happening. The fact that key information is missing or difficult to find also creates problems. There's too much generic information that clients do not need to bother with, or other solicitors, other lawyers do not need to bother with. If you're talking about terms and conditions, you're going into too much detail when you don't need to, and you need to focus on specific areas the client really needs to know. And you also need to ask these questions. So if you look on the right hand side of the screen, in the yellow area, these are the questions that you should be asking yourself as you write these letters. Have you explained what is going to happen over the next few weeks, days, and months in terms of the case? And have you been able to explain when those things are going to happen? Have you put some form of timeline on there so the client understands how long this is going to take, and maybe more importantly, how much this is going to cost? Have you told the client what they are expected to do in this scenario? Do they need to find documents? Do they need to find correspondence, to find evidence? Do they need to contact you? What do they need to do? They need to know in order to be able to do it. Have you included your contact details? Of course you have the letterhead, but maybe if you have a direct phone number or a direct email, that should be included in the letter. Otherwise it's very difficult to get the document back to the client or to the solicitor. Is there a clear purpose to the letter, and does it show a clear purpose? Referring back to the highlighted questions and problems we were looking at earlier, is your letter concise? If a letter is going to 2, 3, or 4 pages, then look at how you can edit it. You can cut it down. Have you used plain English? Particularly important when writing to clients, of course. Have you prioritized the information? Is the most important information easy to find Is it at the start of the letter, or does the client, does the other side, does the court have to try and find the important information? And then again, if you are writing to a client, have you personalized the information specifically for their needs and their uses? Take a step back from the letter, maybe take a few minutes away from the letter and look at it again and ask yourself, is this letter easy to understand and easy to read for the client? And has key information been highlighted so the lawyer or the court or the client understands where to find that information? So these questions you need to be asking consistently. You need to get them into your mind so you understand how to write good correspondence and good letters. And finally, just keep these in mind as well. Each paragraph should make a specific point. If you have a new point, go on to a new paragraph. Avoid contractions and slang and abbreviation. Everything should be spelt out. It should be understandable. And don't forget, when you end the letter, conclude with an action plan. What should the client do next, and what should you be doing next? We're going to take a look at a few different letters now, and the first one we're going to look at is called the client care letter. And it's a letter or an email that's sent in England and Wales to a client after the first meeting between the client and the solicitor, and it gives all the information, it gives all the details about fees, what's going to happen, how long everything is going to take, any expenses, any court proceedings that could occur. So it just gives the client an idea of what to expect from the case. And this one we've chosen because it's very well written, and we're going to go through it and stop at certain points, and also you'll be able to find it in the documents list in this course. So first of all, I liked the introduction here. It says, and I'll read it out for you, this letter sets out some important information about my professional relationship with you, as well as my terms and conditions. It is vital that you read the information carefully. So there you go. You've got the nice long sentence at the beginning and then a short sentence afterwards. Perfect combination. And it's written in very clear English, very plain English, and it's telling you right at the start you have to read this information. It's very important. It continues. I'm sorry about the length of the email. There is a lot to tell you. It is rather formal, and when I talk about my firm, Legal English UK, I have used the firm we or the firm instead of I. That is the way that these things are done, and I don't want to break with hundreds of years of legal tradition. So again, I like that explanation. It's explaining to the client, it's softening the letter in a way. You're going to read some very formal wording, very formal vocabulary, very formal expressions in this letter, but the way it's written is because this is how it's done. Then it goes on. Responsibility for your case. So the person responsible for all the work on your case is Michael Davis. You should contact Michael by telephone or email for advice, updates, and all other matters in relation to your case. And then it goes on to fees, as you can see. Sorry about the formatting here. I think it's because of the PDF. We'll try and change it for the document. Hopefully it'll be normal when you can look at it. And so it goes on a little bit, then talks about expenses for experts, and you can see here where I'm pointing. Again, there's a very good explanation of what's going on. Experts normally send their claims for cost to the court when they are required to attend and give evidence. Should the court refuse to pay their fees, then you will be liable. We may ask you to make a payment in advance of any court attendance to cover this liability. Again, nice explanation there. It's laying out clearly what to expect. Okay, and then we move on. So now we talk about what is expected from the solicitor by the client. And here, some clear words. So I'll read a couple of paragraphs for you. We will update you by telephone or by email with progress on your matter following police station attendances, court appearances, receipt of important information about your case when any important event occurs in your case, and at least every 3 months. So it's nice plain English. I have a few issues with the punctuation. Again, they'll be corrected in the main document. And 3 months I would write THREE, but those are cosmetic changes. The reader is not going to be too worried about that. It's a nice explanation. And then I like that single paragraph there. We will communicate with you in plain language. It's a guarantee, because that's what clients are worried about. Are they going to receive a letter? Are they going to receive a document that is just impossible to understand? Then we move on. So you got there a list of various different responsibilities, and bullet points, absolutely fantastic in this case. Far better than writing an entire paragraph about this. Just list the bullet points, the promises from client to lawyer and lawyer to client. Then it goes on to complaints there. Again, the paragraph right at the beginning, nice and easy to understand. I'll read it out for you. We are committed to high quality legal advice and client care. Short, crisp sentence. If you are unhappy about any aspect of the service you have received or about the bill, please blah 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 blah. Very nice, very clear paragraph. It goes on in the same way, and you have these other issues here. If you complain about the bills, this is what you have to do. There will be interest on unpaid bills. You can see that, possibly. Insurance, there is insurance. Nice, clear part. And then on the storage of documents right at the beginning, again, here's some crisp sentences that tell you everything that's you need to know. So after completing the work, we will be entitled to keep all your papers and documents while there is still money owed to us for fees and expenses. Okay, I understand. We will keep our file of your papers for up to 6 years. We will normally return all original documents such as driving licenses to you. We keep files on the understanding that we can destroy them 6 years after the date of the final bill. So again, nice, easy to understand. And here we've got the termination clause about what to do in circumstances where you want to end the relationship, where the client wants to end the relationship with the solicitor, the business relationship. And let's have a read of that. So you may end your instructions to us in writing at any time, but we can keep all your papers and documents while there is still money owed to us for fees and expenses. So you see it's written in the active voice. I understand completely. No passive voice here. It's all active voice. It's all direct. It's all understandable for the client. We may decide to stop acting for you only with good reason. We must give you reasonable notice that we will stop acting for you. If you or we decide that we should stop acting for you, you will pay our charges up until that point. These are calculated on an hourly basis plus expenses or by proportion of the agreed fee, as set out in these terms and conditions, depending on whether you have paid a fixed fee or are paying for our services at an hourly rate. Clear, easy to understand, written in the active voice, nice conditional there, if you or we decide, perfectly written. And then it goes on towards the end to talk about what happens with third parties. But you can see there, that's a very long letter. I think it's about 4 pages long or 3.5 pages long. It's written very crisply and very clearly in understandable English. It's usually this particular letter is sent as an email, so maybe it's slightly different from what you do, but still active voice. Explain everything to the client, put the most important information right at the beginning. Also, if you recall right at the beginning, there's that sentence there that says it is vital that you read the information carefully. It's a direct statement. You have to do this. Take 5 minutes from your life just to read this letter because it's important. And that's a very well written letter. And in front of you now you have a template for a letter for action. And first of all, one of the most important things is that you have the correct email and the correct address. So they should be there. Make sure you have the correct email and the correct address. Otherwise, the person that you're writing to is going to claim that they didn't receive the letter. In the UK, you can have tracked mail as well. I'm sure it's the same in your country, so you might have to consider that too. You can see there, here on this letter, everything is on the left hand side. As I said in the previous letter, this tends to be the way most law firms do things in the United Kingdom. And don't forget the references. So our ref there has the name of the lawyer, the name of the legal secretary, or the name of the file, plus possibly a date or a file number. Then you have the reference of the other side, which is probably an invoice number in this case. Then, as is normal in the UK, we go day, month, year. And then you start with Dear Sirs because you're writing to the company. There is a comma there. You don't need to add the comma. Some people do, some people don't. The letter there has RE, as you can see, meaning in reference to. That's not necessary. It's up to you. But I would strongly suggest that you don't do this. We have obtained this template from a friend of ours who writes these letters frequently. So you can see that this is a letter before action. A letter before action is telling somebody that you will sue them if you don't receive the money, in this case £5,000. Typically a letter before action is enough to warn people and they will pay. And I think in about 85% of the time this will happen, but occasionally they don't, and then you have to go to court. So you see there, because this letter is short, we can read the whole thing together. We are writing to you concerning the amount of £5,000. That is outstanding. You see there a nice active sentence. We are writing to you concerning a verb. We love verbs. Beautiful sentence to begin with. Nice active voice straight into the second sentence. You have previously been provided relevant invoices and statements, but any request for the further copy invoices or other documents relating to this debt should be made by return. Which means that if you have any questions, return a letter to us or return an email to us asking for a copy of the invoice. Next statement. We refer you to the practice direction, the pre-action protocols, in particular paragraph 15 and the sanctions for non-compliance. You can find these on the Ministry of Justice website at blah, blah, blah. Nice, again, active sentence, very direct. And then in the next paragraph, you can see in bold, clearly, because this is so important, unless payment of this sum is received within 7 days of the date of this letter, court proceedings may be issued against you without further notice. What have we been saying all the way through this? If it's important, put it at the start of the letter. This letter is quite short, so we don't need to worry too much about that, but we've put it in bold because it's important. Next paragraph. Any court proceedings will include a claim for interest from the due date of the invoices, court fees and legal costs, where appropriate interest, compensation and further costs under the Late Payment of Commercial Debts Interest Act 1998 will be claimed. Any further invoices which become due will be included in the claim. That's the small print towards the end of the letter. Very good. If a judgment is subsequently registered against you, it is likely to affect your credit rating. Clearly that's important. That's why it's there in bold. and then we look forward to receiving your payment as a matter of urgency. Right at the end, nice, short, crisp sentence. So there are issues with some of the punctuation and some of the grammar in this letter. We won't concentrate on that. You can look at earlier lessons in this course to understand about that. But as far as the content is concerned of this letter, this is perfectly structured. This is what you should be aiming for. As I've said, we have used a friend's letter before action just to show you what lawyers tend to write here in the UK. We are taking a look at a slightly different letter now. This is sent to a group of people in relation to their mother's estate. So presumably it's the children. Certainly it's the children. You can see there right at the top it's addressed Dear All. Note the small letter for beginning with all, because it's not the name of a person. Then you see the reference underneath, the subject heading, no RE, just straight into it, your mother's probate. And in this case, there has been no small talk. It goes straight into the letter itself, straight into the content. It is a long letter, so no need to say thank you for meeting on blah, 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 blah. Let's go straight into it. This is one tactic. It's unusual. It's your choice. Personally, I would have put a paragraph right after your mother's probate, just to say, I hope you are well, I hope everything is okay, something about it. Okay, so probate obviously deals with the distribution of money after the death of somebody. Let's start with right at the beginning. You each receive an equal share of your mother's residuary estate under her will, dated whenever that was, and you see there the will, so that's what it's going to be known as throughout the letter. It will be known as the will. This is subject to clause 4b of the will, which states that any lifetime gifts your mother may have made should be brought into a hodgepot when arranging distributions. So that means they are distributed equally, and it's a legal term, hodgepot. Then it carries on. I enclose a copy of the will for your information, and it's nicely laid out. Short sentences, short paragraphs, headings. This is a very good way to write a letter. Let's turn to the deed of variation now. We have previously raised the possibility of varying your mother's estate. However, we have not received your confirmed instructions. Therefore, I thought it would be beneficial for me to write to each of you to make you aware that the 2-year variation window, there should be a hyphen there between 2 and year, but okay. 2-year variation window, which provides a unique opportunity to vary your mother's estate in whatever way you wish, will close on the 2nd anniversary of your mother's death, whenever that may be. And so you can see there you've got a non-defining relative clause which provides a unique opportunity to vary your mother's estate in whatever way you wish. Very good use of the non-defining relative clause there. And then in 2.2, another very short sentence that's very appropriate and very useful here. We'll move on a little bit. So then we turn to some of the nitty-gritty, some of the small print involved here. For example, on capital gains tax. So these are the taxes that you have to pay on large sums of money in various different situations, or CGT. So you read there, the redirection of your entitlement will be treated as made by your mother's will for CGT purposes, not you, and so there are no immediate CGT consequences of that redirection for you. And I have to read that sentence once or twice, but it becomes understandable. Probably that not you there is questionable. There are ways to change it, but I think after reading that paragraph once or twice, you can understand what the lawyer is trying to convey. And we move on, talk about consideration, and you can see their next steps. So again, would you put these in different points? Maybe not. I think this would just form the main part of the letter, but okay. I hope that this is helpful. Full stop, nice short sentence. If you have any questions, or if it would be helpful to have a call to discuss this letter, please let me know. There's no need for commas there. I think that sentence flows quite easily, so just don't bother with a comma. Then we have the important information. Remember that you should put important information into bold lettering, maybe underline it too. Otherwise, please do let me know how you wish to proceed by Friday 12th of January at the latest. So that could be underlined as well, but it's fine, it's highlighted. And then as the current beneficiaries of your mother's residuary estate, comma, you will be the ones making the variation. And so if you decide to vary your entitlement in any way, you all need to fully understand the above and be involved in the decision-making process. That's fine. It's understandable. My only argument with 3 is that you don't really need to separate it out like that, but it's a matter of personal choice on the part of the lawyer. So, all in all, this is a well-written letter. There are 1 or 2 issues that where you could have changed, particularly with punctuation, some of the language being used, but it's understandable. The sentences are short, the paragraphs are short, it's laid out very well. Any highlighted information is in bold, as it should be, and there are good explanations, everything as well. Hello, we are looking at the language of contract law now for the next 30 minutes or so, and of course 30 minutes is not enough to cover everything in contract law, so I encourage you to look deeper into the law and the language. This hopefully will serve as a useful aid to help you to understand what to put in contracts and how to draft contracts. So we'll be taking a look in this first part of the series of lessons at the structure and the contract clauses, and the next lesson will look at a particular contract. So these are the contract clauses that you will typically find. The parties will be right at the beginning with the names and addresses of those parties involved. Then you'll have the recitals, more of which in a moment. Definitions, conditions precedent, agreements then, representations and warranties, boilerplate clauses, which we'll mention in a second. Then at the back of the contract you'll have schedules, the signatures and any appendices. And so I'm just giving you an idea of the vocabulary and the language that you should be expecting. And when you go to the next lesson, we're going to take a look at a template of a contract. And if you have any questions, don't forget to message us or to contact us in another way. These are boilerplate clauses that you'll find. So boilerplate clauses are clauses that you will find typically in every contract, or at least in the majority of contracts. They talk about dispute resolution. So what happens if there's a dispute? Does it go to mediation, for example? The governing law. So which law? Is it the law of England and Wales, the law of the United States that takes precedent over this contract? The merger clause, about putting everything into this document. Confidentiality, a non-compete agreement, and indemnification. So these are all boilerplate clauses. You'll find them in most contracts, or certainly most contracts related to the corporate world. So that's the first part of our look at contract law. Don't forget to go to the next lesson where we'll take a look in depth at a particular contract. And here we have a sample contract. We've looked at some of the vocabulary that's used, and now we can look in a little bit more detail about what kind of template you can expect. This is from the United States, but the way we operate in the UK is very similar. So you've got there, you start with a preamble, so it's the parties, and you can see there you've got the date, the name of the parties involved, and you've also got the address and the country of certainly the first party, and the second party, it identifies them as a New York corporation. So obviously we know where they're based. Then we have the recitals. It could also be known as the introduction. So it tells you about the reason for the contract and mentions any third parties if they're involved, and any important terms that you should look out for in the contract. There you can see the use of witnesseth. We don't really use that in the UK. Then we turn to the body of the contract. So these are the main clauses in the contract, the heart of the agreement. You'll see there mention of consideration, so the amount of money involved and the type of goods or the type of services being used. And you can see here, I believe it's a territorial rights agreement. So one company is agreeing to take the license to sell a particular product in a particular region or particular territory. Boilerplate clauses we have mentioned already. So these boilerplate clauses, as you can see there, are clauses that you will find in many kinds of contracts, and you really need to be using them. If you are writing, for example, a contract like this, there will need to be a force majeure clause about what happens if something bad occurs, and there also needs to be a governing law clause. As you can see there, in a tenancy agreement, you'll probably get boilerplate clauses related to what type of responsibility the landlord has in terms of cleaning communal areas of the property. So you'll find boilerplate clauses in every contract. Obviously they will vary depending on the type of contract, but in a dramatic corporate contract like this, certainly you'll find the force majeure clause and the governing law clause. Then you see there you've got the signatures with a witness. There should be as well somewhere a signature for a witness. So here's a description of some of the typical vocabulary. We'll be going through that a little bit later in the course, so no need to do that now. And here you've got the sample contract all pieced together. So you can see there right at the beginning the parties, then we've got the recitals, the main part, and the boilerplate clauses, followed by the signatures of the first and second party. Hello again, and we are going to look at a few contract clauses now, and in this case we're going to look at the recitals. It's also called the preamble, sometimes called the whereas clause, because it clearly uses whereas in it. And the idea behind the recitals clause is to serve as an introductory statement to show the intentions of the parties involved, to show the purpose of this particular agreement and why it has been drawn up. And occasionally you'll see the parties in there, but probably the parties will be in the introduction. So it'll tell a story effectively, a very short story, of course. And the idea is that you should keep it fluent, tell that short story as I've already mentioned, and answer the question as to why the parties have got to this particular position. So why are the parties signing this contract? Why has the contract been drawn up, and why has it been signed? So here's one example. Now obviously this contains a lot of legalese, and the questions of what it is fluent, it is understandable, but clearly there are a lot of words there. Okay, so merely an example for you to get an idea of how one of these recital clauses is written. So it reads, recitals, whereas effective as of January the 25th, 2021, immediately following approximately 2 weeks of paid holiday, Mr. Bracking's employment as Chief Executive Officer and any and all other employment positions that Mr. Bracking may have held at Legal English UK or its subsidiaries, including directorships, shall cease. And whereas the parties wish to make the separation amicable but conclusive on the terms and conditions set forth herein, and whereas the mutual considerations expressed herein are deemed by each party sufficient for their respective promises and covenants, and whereas Mr. Bracking accepts the benefits of this agreement with the acknowledgement that by its terms he has been fully and satisfactorily compensated. That's a typical contract clause, and we've come to see these and understand that they have to contain these legal words. There is about halfway through there a perfect example of that set forth herein. Very legalese, very legal English, and right at the bottom, fully and satisfactorily compensated. Remember, as a lawyer, you have to cover all eventualities, and so you have to include lots of words just to signal to whoever's reading the contract now or in the future that everything is covered. So fully and satisfactorily compensated covers everything. So that's one example. A lot of words there. It's a huge sentence. Would I draft something like that? Probably not. I would split it up into several sentences, make it a bit easier to understand, but we can understand what exactly the person drafting the contract has in mind. Here's another example, which is a little bit easier. So in this case, it's split into A and B. So you've got recitals right at the top. And I'll read it. You can read along with me. The vendors desire to sell certain of their assets, and the purchaser has agreed, number one, to act as a stalking horse bidder in connection therewith. So a stalking horse is somebody who makes the first bid in order to attract other bidders. Okay, so he's acting as a, quote, stalking horse bidder in connection therewith. And two, in the absence of the vendor's acceptance of a superior proposal to the transaction in accordance with the bidding procedures to purchase certain assets of the vendors subject to the terms and conditions set forth in this agreement and in accordance with Section 36 and other provisions of the bidding procedures order. And then it goes on, and we'll look at that in a second. So again, there's far less legalese in here and far more fluent language. I like the use of the word desire. The vendors desire to sell certain of their assets. It's a great first line. It tells you everything. Stalking horse bidder. A native speaker would understand what that means instantly. So it's useful to include it in there rather than giving a big definition of what it means. And then on to B. The vendors will obtain the bidding procedures order to authorize the vendors to enter into this agreement and authorize the sales process with respect to the purchased assets pursuant to the bidding procedures. So again, nice simple clause. It's part B of that recitals clause. As I've said, they've been split into two parts. Nice and fluid. That's what you should be aiming for, ideally, making things as clear and understandable for anybody who's reading this agreement, either now or in the future. Hi and welcome back to the Legal English Writing Masterclass with me, Mike Davis, and we are going to continue our look at some contract clauses right now. This time we're going to look at the conditions precedent, and the conditions precedent, it's a very important clause that you will occasionally see in agreement, not always, and it will mention events that need to have occurred before the contract can come into force. So in other words, there need to be certain conditions in place before the contract is legally valid. And so, for example, if you have a will, it's quite frequent that the deceased will have mentioned that somebody who is due to receive money must be of a certain age or must first get married before they receive that money. So that would be an example of a condition precedent. This condition needs to be in place before they can receive their inheritance. And these are some of the questions that you might like to ask when drafting a conditions precedent clause. What is the deadline for this particular condition to be met? Because if there is no deadline, then the contract could obviously go on for years and years. What would be the consequences of non-fulfillment? So if it's a fundamental part of the contract and this particular condition is not met, does it mean that the contract is no longer valid? This is a question you need to ask yourself. What are the steps to fulfilling this particular condition? And what is needed there, and is there a particular clarity as to what steps need to be taken? Remember, when we draft these agreements, we should try and be as plain and clear as possible so everybody understands, not just now, but in the future. And question 4 is, how is the fulfillment determined? Is one party required to confirm that the condition has been fulfilled, or is it just assumed? So these are questions that need to be asked. We're going to look at 2 examples of conditions precedent now. These are basic examples because we don't have the time to look in great detail at particular clauses like this. So if you need to find more information, I encourage you to do some research. So here's one example. The effectiveness of this agreement is expressly conditioned upon receipt by Legal English UK of an executed copy of this amendment. So that's in reasonably plain English, and it means that as soon as Legal English UK receives a signed copy, an executed copy of the amendment, then the agreement is effective. And this next clause is very similar to that one. The amendment shall become effective and be deemed effective as of the date first above written upon receipt by the agent of one copy of this amendment duly executed by each of the parties hereto. So very similar to the previous clause, a little bit longer in vocabulary terms, but essentially says the same thing. As soon as the agent receives the copy of the amendment that has been signed, then the agreement can become effective. So that's a look at conditions precedent clauses. Thank you so much for listening to this lesson. I'll see you at the next one. Hello, we continue now to look at contract clauses. We're going to take a look at the liquidated damages clause, and bear in mind that the law has changed slightly on liquidated damages clauses in England and Wales. So I encourage you to look up the law at the moment, because the Supreme Court made a decision within the last 6-7 months or 12 months at the time of recording this. So let's assume that liquidated damages clauses and penalty clauses are different. but bear in mind that the Supreme Court of the UK has clarified their position on this. Okay, so bear that in mind. So liquidated damages clauses, they deal with potential breaches of contract. There is typically a promise to pay a particular sum, a detailed sum, as compensation if there is a breach of contract and there is a delay in the performance of the contract, and the sum is typically fixed and written down. I'm going to show you a couple of different contract clauses regarding liquidated damages where you will see the sum is mentioned there. And once again, bear in mind, this is not legal advice. This is merely a guide as to the language that one should use in the liquidated damages clause. So the first one comes from a very good book. It's called International Legal English by Amy Croyce-Lindner. I think that's how you pronounce it. I was looking around for some very good examples of contract clauses on liquidated damages, and this was by far and away one of the best I could find. So thank you, Amy. I appreciate it. Here we go. So let's look at it. Stop where we need to. So it is mutually agreed by and between the parties hereto that time is of the essence. Okay, so that's the first one. And so by and between, two prepositions cover everything, and time is of the essence means time is extremely important in this case. So time is of the essence, and that in the event of the contractor's failure to complete the contract within the time stipulated and agreed upon, the owner will be damaged thereby. So what it's saying there is that if the contract has not been performed by the contractor, then the owner will have suffered financial damages, and because of this, the next part of the clause comes into play. So because it is difficult to definitely ascertain and prove the amount of such damages, inclusive of expenses for inspection, necessary traveling expenses, and other similar expenses, it is hereby agreed that the amount of such damages shall be the liquidated sum of £2,000 per calendar day for each day of delay in finishing the work in excess of the number of working days prescribed. So it's £2,000 for each day the work cannot be carried out and of which it is delayed. And the contractor hereby agrees that such sum shall be deducted from amounts due the contractor under the contract, or if no amount is due the contractor hereby agrees to pay to the owner as liquidated damages and not by way of penalty such total sum as shall be due for such delay, calculated as aforesaid. So when they get the final bill, they can deduct £2,000 for each day of delay. And as you can see there, even though it's written in quite formal legalese, as you can see, it's still understandable. And I would say that's a very good contract clause for liquidated damages. So we found another example here. Let's take a look at that. A little bit simpler, this one. So in the event of delay in whatever completion, the performing party shall pay liquidated damages to the owner in the amount of $2,000 a week, or a percentage of the total contract price per day. So the parties agree that liquidated damages as described in this agreement are a genuine estimate of the owner's foreseeable damages and are the owner's sole remedy for such delay. Delays caused by force majeure events or by actions of the owner shall not constitute a delay resulting in the payment of liquidated damages. So you see there, right at the end of that contract clause, a bit of a caveat saying that if it's a force majeure event, then they will not have to pay for the delay, which is perfectly understandable and which you might like to include in your clause. So that's a look at liquidated damages. Thank you so much for this, and as always, if you have any questions, don't forget to message me. I'll do my best to answer them. Thank you. Hello there. We're taking a look at retention of title clauses now here at the Legal English Writing Skills Masterclass, and these are the key takeaways that I want you to remember about ROT clauses, retention of title clauses. First of all, the seller will keep ownership until they have been fully paid, and that's when title or ownership moves to the buyer. And so a retention of title clause should identify the goods and also clarify what the buyer may do with them. So, for example, you can have goods that can be turned into something else. So, for example, if I buy a load of bricks, I can turn that into a wall or a house. And so there is a change in the use of the goods or the items. So you need to clarify exactly what the buyer can do with the items, and in some cases even talk about where in the warehouse they can keep those items, that they can be fully labeled. There are many things that can be included in these ROT clauses. We're going to look at a couple of examples, 2 or 3 examples right now. These are very simple, but they do show you in very easy terms what you should be including in an ROT clause. So here's the first example. So ownership of the goods described shall not pass to the buyer unless they have been fully paid for. Ownership of the goods described shall not pass to the buyer unless they have been fully paid for. So it's a simple ROT clause clearly stating that the goods do not become the property of the buyer until everything has been paid. Here's another example for you. This is a little bit longer, but it explains very well and covers a lot of eventualities. I like this example. So unless otherwise provided herein, so unless otherwise provided in this contract herein, title to the goods shall pass to the buyer once the purchase price is received by the seller in full. So very similar to the previous clause. Once everything has been paid for, then ownership of the goods passes to the buyer. And then we have the additional part of the clause which clarifies what happens if something goes wrong. Risk of loss or damage to the goods shall pass to the buyer in accordance with the provisions of the agreed Incoterms 2020. So then we're talking about transit, about delivery, and when exactly the buyer takes and bears responsibility for anything that goes wrong with the products. And a final example. Any or all courses provided by Legal English UK remain the property of Legal English UK for the duration of this agreement, and upon termination the course will be returned to us. So that clarifies that if we lend courses to somebody, they remain the property of Legal English UK for the entire duration of the contract, and then when the contract is finished, the course is returned. Purely an example, purely an example. So I hope you get a better idea of what an ROT clause is and the kind of language that you should be including in it. Sometimes it will be this short, and as long as it tells everybody who is interested what the issues are in this particular instance, it's going to be fine. Sometimes it's going to be longer. It's going to clarify a lot more. It obviously depends what kind of goods, what kind of services, what kind of products that you're dealing with in this particular agreement. Hello, we are going to continue our series of lessons on contract drafting terms today here on the Legal English and Business English channel. And we are going to look at the merger clause today. And before we do that, I just want you to make a note of our page on Instagram. That's at Legal English UK. We're also on Twitter at Legal English UK. So head over to those two pages after you've watched this video, follow us, like a few of our posts, comment, feel free to get involved. We like hearing from you and we like learning what you want from us. Don't forget also you can comment here on YouTube. We're happy to read your comments and we'll try and respond to them as best we can. You can also go to the website legalenglish.co.uk, have a look around, learn about our courses, learn about the books that we offer, learn about various lessons that we have, various articles we have on the blog. Spend a few minutes at legalenglish.co.uk. So the merger clause is a complete and exclusive statement that puts everything into the one document, into the one contract. So it's saying that any discussions that were had before, any telephone calls, any letters, any other documents are irrelevant now. It's all about the document in front of you, the document in front of the judge if it comes to court. That's the information you need to use. Otherwise, you would have problems. You'll have people searching for letters that were sent 2, 5, 3, 4, 5 years before the document was agreed. That document written on that piece of paper is everything that you need to tell you what is in the contract. And a merger clause will state this. And in a second, we'll look at some of the drafting that you should be using when you're talking about a merger clause. Now, in the UK, most spoken agreements are completely legal and enforceable, except in some circumstances, property being an obvious example. But, of course, as with everything, you should really get it in writing. Otherwise, you get a situation like this. Okay? You get the cat, a former client telling you, I didn't sign anything, I don't have to pay you. So get it in writing. Crucial advice, which I'm sure you know already. Now here's a sample merger clause. Let's take a look at it. And this is the type of language you should be using. It's very legal, I know, but that's the way things work in contract law, right? That has to be lots of words, lots of vocabulary, lots of hereins, lots of heretos. We're trying to change things. We're trying to change things. I'm sure you're trying to change things too. But at the moment, this is how a contract is written. So this agreement constitutes the entire agreement by and between the parties. And any other prior representations or agreements are deemed merged herein. Okay, so everything else that was said before is part of this document. And those not specified herein do not represent any agreements or promises or covenants or representations on the part of either party hereto. So if the document is not mentioned in this contract as being part of the whole agreement, then you can ignore it. And if you haven't already, don't forget to subscribe to this channel. Here's another example of a contract clause, very similar to the one we saw just now. This agreement supersedes, so it takes over. This agreement supersedes all prior agreements and understandings between the parties and may not be changed or terminated orally, and no attempted change, termination or waiver of any of the provisions hereof shall be binding unless in writing and signed by the parties here too. So again, a few more here twos, but maybe a little bit more in plain English than the previous one. But it's saying the same thing, right? It's saying exactly the same thing. This agreement is the only agreement that is relevant. So in the unlikely event that this issue comes to court in the future, the judge can look at that clause and he can understand that this is the only document he needs to see. He doesn't need to call on any other evidence. I remember some contracts are hundreds of pages long, very complicated. Judges don't like complicated. Everything's in that document. It's fabulous for the judge. Here are two videos that I would love you to watch next. Take a look at them, comment on them, like them, and don't forget, we're also at Legal English UK on Instagram, Facebook, and Twitter. I've been Mike Davis. Thank you so much for watching. I'll see you soon. And welcome back to the Legal English UK YouTube channel. What we're going to do now is continue our series of videos looking at contract clauses. We're going to look at boilerplate clauses, which are very important in contract law, and we'll also try and analyze one specific boilerplate clause for you. It's a really good video, so enjoy it, and we'll speak soon. So that's what we're going to look at today, boilerplate clauses. They are so called because of the boilerplate. Now these were printed sheet metal that were placed on two boilers, millions and millions of boilers. So it essentially said the same thing, and they were printed out and printed out. Another inspiration is from the newspaper industry, where texts were published, millions and millions of them, all saying the same thing and sent to newspapers across the United States. Don't forget to follow us on Instagram, by the way, at Legal English UK. So these are some boilerplate clauses on governing law, confidentiality, on a notice period, on arbitration, on force majeure, on jurisdiction. Boilerplate clauses usually feature in every contract, and if they're not, and we'll show you what happens if they're not, then there could be a problem. So governing law is the area that we're going to look at today. We're going to take a look specifically at this contract clause because it is one of the most important, and you will certainly find it in serious contracts, in major contracts that involve millions of pounds, millions of dollars. Why is governing law so important? Well, the parties need to make a decision. Which governing law do they use? Which jurisdiction do they use? Do they go to England and Wales, or do they go to the US? Because with contract, everybody needs certainty. You need certainty of which jurisdiction is responsible. Because if something goes wrong, there could be litigation, and it's going to potentially cost a lot of money. We're talking thousands of pounds, hundreds of thousands of dollars, if you are not certain where the jurisdiction of this contract lies. And if you think of the City of London, a very important city, and there are so many international transactions, so many financial transactions taking place in London, so many contracts being formed around the world, that it's important. Take a look at this case, Apple Corporation against Apple Computers. Apple Corp is the music business of the Beatles, the band The Beatles, and they had a case with Apple Computers, and there was a question about the governing law. There was nothing in the contract about governing law, and the judge at the High Court in London said The evidence before me showed that each of the parties was overtly adamant that it did not wish to accept the other's jurisdiction or governing law, and could reach no agreement on any other jurisdiction or governing law. Neither party wanted to give the other an advantage in terms of where the agreement was finalized. If their intention in doing so was to create obscurity and difficulty for lawyers to debate in future years, they have succeeded handsomely. So, it's important, if you have a major contract involving millions of pounds or millions of dollars, there should be a clause, a boilerplate clause involving governing law and jurisdiction about which court should hear the case. Don't forget, by the way, to subscribe to this channel and like the video. Now, the governing law and the jurisdiction clause should really be the same. Governing law involves the law being heard in this case, and jurisdiction is about the court. So obviously, if you are dealing with French law and you say that the jurisdiction is England and Wales, there might be an issue. Translation, understanding the French legal system, a myriad of reasons. And there might also be technical reasons why you choose the governing law from a particular area. Because in some laws, in some countries, certain aspects of business, of corporate law are recognized, whereas in other countries they might not be recognized. For example, with trusts. In New York and England and Wales, trusts are recognized and well known. So, in that case, you would want your case to be heard in England and Wales or in New York State. Here's an example of what a governing law clause could be. It's short, it's sweet, but it tells you everything you need to know. This agreement shall be governed by and construed in accordance with the laws of England and Wales. And that's also a perfect example of a watertight governing law clause, because you see laws of England and Wales written there. Do not write to the laws of Great Britain or the laws of the United Kingdom, because that legal system does not exist. Remember, England and Wales, Scotland, Northern Ireland, 3 different legal systems. We need to write the laws of England and Wales. Thank you so much for watching this video. Don't forget, there are 2 videos there that you should be watching next. And also subscribe to this YouTube channel for more exciting content about learning legal English and business English. See you very soon.